for an initial fixed fee interview, which enables us to meet with the client and try and get a better understanding of what the legal issues are, what the grounds for divorce might be, whether there are any financial matters to consider, children, etc. I'm one of 4 qualified lawyers in the family team, so you would be coming in to meet with either myself or one of my colleagues so that we can have that initial meeting and advise on options, and then we can take it from there. There are 5 legal grounds for divorce. The first one is adultery, and the second one is unreasonable behaviour. Behaviour grounds are somewhat difficult to advise clients on. The courts have various behaviour particulars that they will accept, so we do have to guide clients in terms of what is specific to their case that we can rely on, and we can assist the client in drafting a petition on that basis. One of the most common grounds is 2 years separation with consent, which is where parties will wait 2 years after they've separated and then look to divorce then. It's a more amicable way of dealing with it. One of the more rarer divorce grounds is 2 years desertion, and then the final one is 5 years separation. I would say it's usually 6 to 9 months, but that does depend very much on how quick the court take to process the paperwork, and also how quickly the opponent replies. It also is the case that where there's complex financial matters, we would never advise a client to proceed to decree absolute unless we've first talked to them about finances and guided them and tried to resolve that, because once parties are no longer spouses, it can impact financial claims, so it is important that clients do seek advice as regards financial aspects as well. So when a client comes in to talk to us about divorce, we will always also consider the finances. And one of the first things to do to be able to guide a client as to what their entitlement is to look at what the assets are. So we would write to the opponent to try and get some voluntary financial disclosure, to try and do it as amicably as we can. That may include property valuations, business valuation reports, sometimes pension actuaries reports, just basically so that we can get a broad idea in terms of what the assets are. We can then advise the clients as to what their entitlement may be, taking into account their specific needs. We guide clients by virtue of what the courts would do if we were in a court process, and the courts take into account various things such as needs and resources, financial contributions, and sometimes conduct as well. So it is quite a complex area of family law, so it is something that we would guide clients to come and get some help with. Wherever possible, we try not to get the clients involved in court processes, and we'll try and resolve things as amicably as we can. Court is very much a last resort, but unfortunately sometimes clients can't agree things directly. If an opponent is difficult, then obviously it takes 2 to reach an agreement, so the court process sometimes is inevitable. It usually tends to be in Children's Act cases that can follow, and there are various options available to the court to assist the parties in governing what the correct care arrangements should be for children. But the court can also deal with emergency measures where there's domestic violence, and also where there's been threats of removal of children or safeguarding issues. We can also advise and guide in that regard too. As your local solicitor, please either visit the website or give us a call, speak to either me or a member of my team, book in to see us.